Hi everyone. Thank you for coming here today. The webinar will be starting now actually. So thank you for your patience. And I'm Vanetta, a legal associate with our firm. And to start off on behalf of our firm, Cheong LLC, I would like to extend our appreciation to each and every one of you for taking the time to support our firm's webinar session today. By way of introduction, we are a boutique IP law practice based in Singapore, and we have an office in KL, Malaysia as well. So in terms of the services that we provide, we do offer a comprehensive range of IP services, such as prosecution, enforcement, commercialization, and strategy work. And we are specialized in assisting our clients with managing their global IP portfolios with a particular focus on the Southeast Asian and Indian subcontinent region today. Our speaker today, as shown on the screen, is Bryan, who is a legal associate with our firm, and he's currently based in our Singapore office. So Bryan is experienced in both trademark prosecution and IP commercialization work, and has assisted our clients from a wide range of industries with the management of their trademark portfolio. So today he'll be presenting more on the trademark ownership, as well as to better commercialize the trademarks for your business. So before we start, please note that it is an interactive session and Bryan will be having live polls along the way. So if you have any questions along the way and during the presentation itself, do ask them in the Q&A chat box at the bottom of your screens. And we do note that we'll be having a Q&A session after the webinar as well. And Bryan will be answering these questions along with one of our directors, Kevin. So please stay tuned to the end of the webinar if you have any questions that you want to ask. So for now, Bryan will start off with the webinar. Yeah, Bryan, please.
Okay, thanks, man. Thanks for the
no worries.
Okay, good afternoon, everyone. I am Bryan, a legal associate with the firm, and I'll be taking you through an introductory module of sorts, looking at the commercialization and ownership of trademarks and what you can do to better further your commercial interests as far as trademarks are concerned. Okay, so if you will just give me a moment, I am currently sharing. Okay, so this is the title, and as the title suggests, we will be going through trademark ownership and commercialization and how it can benefit you as both as prospective trademark owners as well as current trademark owners. So the presentation agenda is as follows. We have learning outcomes classified by 3 categories. Basically, we'll be looking first at the subsistence of trademarks, namely the registrability criteria for how trademarks are registered in the respective registries. And once we establish that, we'll be looking at how to better protect your registered trademarks by exploring options for such protection, determining the territory for protection of trademarks. For example, are we going by a domestic route or are we going by the international route via the metric protocol? And from there, we will be establishing general guidelines for coming up with your own filing strategies. And once we have established protection part, we will then move on to review issues, common IP issues in the commercialization of trademarks. So in that, we'll be looking at how trademarks are commonly used, how trademarks are commonly assigned and licensed. So before we dive into the content proper, as a prospective trademark applicant, you might be asking yourself, why do I need to register a trademark? So from my experience, I think there are 4 key reasons as to why you should seek to register a trademark. Firstly, a trademark is a legitimate proof of ownership of the mark, and as such prevents others from registering and using similar marks. Next, having a trademark registered is a proof of ownership on the register and provides ease of enforcement of this registered mark, as opposed to an unregistered mark in which there is an evidential burden to overcome in terms of showing either that it has goodwill subsisting in the mark or there's some reputation that you want to protect that subsists in the mark. Third, having a registered trademark legitimizes the ownership and use of the registered mark, and by extension prevents others from claiming infringement from use of your registered mark. And finally, a very big part of this presentation would be looking at the commercial exploitation of the registered mark, namely, how do you monetize your registered trademarks. So looking at the first part of the presentation, which deals with issues of trademark subsistence, we'll be dealing with two key considerations right here. Firstly, we'll be looking at the distinctiveness requirement of a trademark, both inherent and acquired. Next, we'll be looking at similarities with potential earlier marks. Earlier marks meaning either earlier marks that are registered on the register or earlier marks that subsist as a result of a reputation agreement. So before we dive into the content proper, I would like to engage everyone in a poll. And so, Bern, if you can assist me to pull up the poll questions.
Yeah, sure. So everyone, please help to key in your answers, whichever that you think is correct. Yeah.
So yes, there's 5 options here, and I would like to ask for everyone's opinion. So which of the following combinations of words are not likely to be registrable as a trademark?
I'll give everyone about a minute to put in their answers. Yeah. Okay. Maybe about 10 seconds more before I launch the poll results. Okay, so I'll end the polling now, and we can take a look at the results and see whether Bryan has anything to share about it.
Okay,
Yes.
thanks, Bern.
No, no worries.
Okay, so from the poll results, it's quite interesting. Most of you have said that clean and green for recycling services will not be likely to be registrable as a trademark. And then 3 of you said save the planet for automobiles, and then 2 and 1 of you respectively for wheelsmiths and both. Okay, so yeah, I would like just to comment on the results. Okay, so each of these 5 examples of word marks are actually what I would term as different types of trademarks that are on the spectrum of inherent distinctiveness. So what is inherent distinctiveness? Inherent distinctiveness, right here, we're talking about the innate quality of a trademark to function as a trade origin to consumers. So when consumers look at this mark, they'll be thinking, oh, yes, the goods and services represented by this mark must originate from a certain source. So there must be a certain element of distinctiveness and uniqueness surrounding these word marks. So with this general principle in mind, clean and green falls at the left far end of the spectrum as a rather generic or descriptive mark, because clean and green clearly describes some environmental message relating to environmental and cleaning services. So for this kind of marks, it is generally in the public interest to make sure that these words can be commonly used by other merchants in the same industry. So as we move along the spectrum, we look at slogans next. So previously, there was the Save the Planet example for automobiles. So likewise, Save the Planet is quite a generic sort of word combination. And it, as such, it might not be sufficiently unique or distinctive enough to function as a trademark. And then we move on along the spectrum and we move on to suggestive marks. Suggestive marks in this case, for example, wheelsmiths in my previous example. Suggestive marks, as the name suggests, would be marks that are either imaginative and not directly descriptive of the goods and services in question, and as such may be able to function as a trademark because they might be distinctive from the eyes of the registry. Then as we move down, we look at arbitrary marks and purely invented marks. The argument is stronger because there is no relation between the mark in question and the goods and services sought to be registered. So, and viewed as a whole, this is how inherent distinctiveness is assessed. So, assuming that your mark is somewhere on the left side of the spectrum, something that is not so much inherently distinctive, what can you do? So, there is an alternative approach, which we call acquired distinctiveness, which basically is distinctiveness through extended commercial use. So from the Singapore registry, what they generally look at is at least 5 years of use prior to the trademark application. And this use has to be shown through commercial means. What we mean here is application on common commercial documents, such as invoices and turnover related documents showing sales, as well as extensive marketing and advertising documents. So all of this, when viewed as a whole, can paint a picture of showing that the mark has been put to use for an extended amount of time, so much so that consumers nevertheless come to acknowledge the mark as being representative of the trade origin behind it. So that's the entire basic idea of acquired distinctiveness. So with these two types of distinctiveness in mind, here are some useful tips for establishing distinctiveness. So in the example of clean and green just now, just remember to avoid adopting common words as trademarks, unless if read together as a whole, it makes no sense, or it's obviously arbitrary and completely unrelated to the goods and services in which it is represented. And or finally, it contains some prominent or distinctive logo along with the common word, such that the distinctiveness character is shifted from the common word to this prominent and distinctive logo. And secondly, to deal with the acquired distinctiveness point that I have earlier established, it is important for trademark owners to keep records of use of the mark in the event that when it comes to registration, you are called upon to show that even though the mark does not have inherent distinctiveness, it has acquired distinctiveness because of its extended usage and its extended interaction with the relevant consumers. And finally, very importantly, do not use your trademark as a verb or a noun with respect to goods and services. So as an example, do not use your trademark in the sense like, let's Google this search result, or there's as a verb, or as a noun, let's go up the escalator. So these two are examples, very common examples of trademarks that have become generic as a result of their use in commonplace conversations and everyday life. So we have established the distinctiveness requirement. So next we look at another very common objection that registries will raise with regards to registering your marks, namely a conflicting mark. So what is a conflicting mark actually? So firstly, it is a mark that is either registered currently on the trademarks register, is well known in the eyes of the local populace, or has goodwill attached, that is a local custom that is drawn to this mark. For well-known and goodwill, there is an evidential burden that has to be crossed by the relevant mark owner. Next, we look at visual, oral, and conceptual similarity between the earlier mark and your current mark that you seek to register. So conceptual similarity here will be if they are of similar meanings. And once we establish the three similarities, we look at similarity of goods and services, namely whether the goods represented and services represented are similar or are they different. And then taking the mark similarity and the goods and services similarity as a whole, whether or not the relevant consumer exercises sufficient care so as not to be confused or not. So this entire inquiry is put before the registry, who will decide in view of the totality of factors to decide whether or not the mark is confusingly similar, or rather the earlier mark and the mark you seek to register is confusingly similar. So practically speaking, what should you do to prevent likelihood of conflicting earlier marks? So the first thing is to conduct a conflict search to see if any identical or similar marks exist, either on the trademarks register or when you're looking for well-known marks or marks that have goodwill, you search for them on the market. So what you do here is you generally engage a private investigator and you conduct your own searches on the internet to see if any such mark exists. both of which can be done by engaging an IP specialist to assist you. And then you assess the risk based on mark similarity and similarity in goods and services, as well as the reputation of the other mark. And if there is no conflicting earlier mark, generally you should be filing the trademark application ASAP, because your trademark rights and as well as the assessment of the mark is taken at the point of the application date. So summing up this part of subsistence as a whole, first things first, conduct clearance searches to prevent and identify any likely conflicting marks. Next, obtain registrability opinions that look at whether or not the mark is sufficiently distinctive and whether or not the mark has any conflicting marks, and if so, what can be done to overcome these conflicting marks. And finally, to deal with acquired distinctiveness objections, maintain extensive commercial records of your trademark from the point of trademark usage. So we have established that trademarks can subsist provided that the requirements of registrability, the requirements of distinctiveness and conflicting marks are met. So next we'll be moving on to how to protect your marks by availing yourself of the proper filing procedures, both domestically and internationally. So we'll be dealing with two key concepts here. Firstly, the territoriality of IP, and next, filing and renewal dates. So looking at firstly at the territoriality of IP, we'll be comparing national filings through the domestic IP offices as opposed to international filings through the Madrid Protocol. So firstly with national filings. So national filings, what we have here is, broadly speaking, a rather general structure for what takes place in most domestic IP offices. So first you file an application. Next, the office goes through a formality examination to determine the owner of the marks, the addresses are correct, things like to do the formal requirements. And thereafter, the office then looks at the registrability requirements which we've gone through in the first part of this presentation. And assuming that all is clear, the mark will then proceed to publication, which is a period of time in which the mark is published to the general public, and it is then open to the general public and whatever interested third party to oppose the mark on registrability criteria. And assuming that publication phase is passed, which is generally 2 to 3 months, the mark then proceeds to registration. So now you compare this to international filing through the Madrid Protocol. So what is this international filing through the Madrid Protocol? It is basically relying on a base application that is made through the domestic office of a country, a member country of the Madrid Protocol, and then transmitting this application to WIPO, who will receive it and formally examine it, and then forward the application to each of the designated member countries that you want to register in. So to give an example, I have an application that is domestic in Singapore. I transmit the application, the base application in Singapore to WIPO, and then I designate member countries such as Thailand, Korea, Japan. And their respective registries will deal with the substantive examination of the mark as per their own trademark laws. So if you compare this Madrid Protocol filing in multiple countries as opposed to individually filing your trademarks domestically with the registries themselves, the advantages are quite clear. So firstly, there is only one application to be filed. And with that, a single set of fees are payable for this application. And because you are not going to the domestic offices directly, filing with documentation such as statements of mark ownership, powers of attorney, they're all reduced unless the national office raises objections. And with that, past a certain point in the number of marks you want to file, there are potential cost savings to be had. But bearing all of this in mind, because the Madrid Protocol substantially relies on this base registration, so and everything is consolidated under this base registration. So everything succeeds and fails based on this base registration, which leads me to talking about this concept of central attack. So within the 5 years from the registration of the base registration, the base registration is liable to if the base registration is under attack, meaning if its registrability criteria is called into question and the mark is then invalidated, for example, the other designated marks in the other member countries will fail as well. So that is something to think about when you're considering filing through the Madrid Protocol. So once we've established whether or not to file through the Madrid Protocol, and you successfully obtain a registration in each of the countries that you want to file your marks in, we look at renewal next. So generally for trademarks, the term of trademark subsistence is indefinite, provided that you subscribe to the renewal period. So for trademarks, depending on the jurisdiction involved, is every 7 to 10 years. And finally, depending on the jurisdiction you want to file in, the use of the trademark might have to be declared. And if you do not declare it, the trademark might be revoked by the office. So for example, Philippines has a requirement in which you have to declare use 3 years after you register the trademark, and then subsequently 5 years after you register the trademark, and after that it's within a year of the renewal period. So there are quite a few a declaration of users that you have to go through to make sure that the mark subsists on the register. So to conclude on this part of the presentation, when you want to look at filing in certain jurisdictions, you look at whether or not these jurisdictions are members of the Madrid Protocol. And then next, determine if you can, which is whether you can avail yourself of the Madrid Protocol or whether you should utilize the Madrid Protocol. In this case, it is important to note that although certain countries allow for Madrid Protocol, it might not be necessary or even advisable to go under Madrid Protocol because of the difference in specification requirements for goods and services. For example, when you translate the goods and services in the Chinese office, for example, it might not pass muster under their own substantive examination requirements. So under such circumstances, it might be more prudent to go under a domestic route. And next, you can compare the cost between filing purely domestically, purely Madrid Protocol, or mixed domestic and Madrid Protocol, and view the cost of totality to see which is more cost effective for you. And finally, because trademark rights generally subsist from filing date, you would want to plan your filing strategy around your intended date of product, service, and launch. So you want to, as soon as possible, get your trademark rights at the point of the application date, and then from there, decide on how you want to launch your service or product that is represented by the trademark. So after we've established protection of trademark rights under both the domestic and international regimes, we look at what you can do with your trademark in terms of commercializing it, in terms of monetizing it. So the first thing and the most obvious one is to use it yourself for your own commercial purposes and use it in relation to your own services. The next is to either assign it, which is to sell it, or maintain ownership, keep ownership for yourself, and allow others to use it for a fee, which is what we term as license. So if you want to use it yourself, here are some useful tips that you should be thinking of. So firstly, definitely, because like I said, trademark rights are perpetual, generally perpetual, as long as you pay your renewal fees on time. So always remember to pay your renewal fees for as long as you intend to reap the commercial benefits of the trademark. Next, use your trademark with the relevant markings, depending on jurisdiction. So in Singapore, it will be a TM sign right beside your trademark to clearly show that you're using it as a trademark. And thirdly, it's important as a trademark owner, a registered trademark owner, to watch out for potential IP infringers and to do so actively. So this can be done by engaging professional IT services known as watch services, where IT professionals will be scouring the market, the relevant market in question, to look out for potentially similar trademarks that you might concern yourself with. And finally, ensure that the trademark is used in the exact form that it is registered as, and also in relation to the goods and services that you have registered the trademark for. This is important, firstly, to prevent yourself from unknowingly infringing a potentially similar mark, and also extensive use of the mark in the form as prescribed is extremely important evidence to show that the mark is being used, which can be useful in the event that a revocation action is mounted against a trademark. So next we move on to assignment of the mark. So from our experience, why do parties like to assign the mark, which is to sell the mark? So the first thing is we have clients coming to us telling us that we want to consolidate trademark ownership within a large corporate group, within one company, so that it's a lot neater in terms of when we have to renew the trademark, when we have to license out the trademark, etc. So it is important in terms of corporate governance for some company and some corporate groups to consolidate these trademark ownerships within a single entity. Next, and probably the most straightforward reason for assigning a trademark would be a one-time realization of the monetary value that you've accumulated in the trademark. So any goodwill, any reputation, any attraction of customers, all of it will be accumulated in the trademark. And when you do sell it, you realize this value in one lump sum. And finally, trademark assignments are very common as part of the sale of assets in mergers and acquisitions on a corporate scale. So if you want to sell your trademark, what are the general steps to undertake? So first, the most importantly, is to obtain valuation for your trademark. So in this regard, you'll be looking at how much sales as a trademark generated, how much goodwill as a trademark generated before arriving at the valuation of your mark. And also to note jurisdictional requirements for what constitutes a valid assignment. So what do I mean by this? In Singapore, generally, an assignment only needs to be in writing and assented to by the assigner for it to be valid. However, in countries like Indonesia, the assignment has to be recorded with the relevant IP office or it's valid in law. Next, looking at the limitation of assignment, you can limit the assignment of the trademark by A, assuming that your trademark is registered in multiple territories by the countries in which you assign the trademark in. So for example, you have a trademark registration that spans Asia, but you only want to assign it for Singapore, you can do that. And also the assignment can be for in perpetuity or for a fixed term, like 1 or 2 years, for example. And finally, if you still want to use the trademark in question, it's always open to you. Assign it to a third party first, and then license it back. So we'll be moving on to talk about what licensing of trademarks are. But before that, here is another poll, which I would like everyone to answer. But can you?
I'll launch the poll now. So I'll give everyone about 1 minute to answer, just like the previous question.
So yeah, I just want to ask everybody, based on your general understanding of how global businesses are run, which company do you think is a top global licensor in terms of the monetary value of licenses granted to third parties?
Okay, seems like the answers are coming in. So maybe about 20 more seconds before I close the poll and launch the results. And perhaps Bryan will want to comment on it later.
Okay.
Okay, I'll be Okay, I'll share the results now. So, yep, Brian, if you have any comments.
Oh, okay. Wow, very interesting. So as I can see, the results are more or less split halfway between Walt Disney Company and Microsoft. Okay, the answer is actually Walt Disney Company. Okay, for Microsoft, they are quite prolific in terms of software licensing, copyright licensing. But for trademark licensing, it's mostly Walt Disney Company, in part due to the fact that they've acquired a lot of different trademarks and IPs from Fox, from Star Wars, from Marvel, for example. So as we look at the next slide, we look at why people license trademarks. We can maybe understand why is it Walt Disney that is the top global licensor in terms of trademark licenses. Okay, so why do we license trademarks? So in the example of Walt Disney, what they usually do is they want to allow third-party usage of brands, of their own house brands, while preserving some degree of control and as well as absolute ownership of the mark. So it's very common for product distribution, namely when you have produced a product with your brand on it and you need a third party to distribute it to an external territory and sell it from there. Next is also merchandising, when you want to collaborate with third parties to produce certain goods and services, and you want these goods and services to be accentuated by the usage of your brand. You adopt a merchandising approach and you license out your trademarks under this merchandising approach. And finally, if you have certain know-how, certain goods and services that you want to franchise out for a third party to manage and to exploit monetarily, you can also trademark license. So looking at these three examples, I think it's quite clear to see why Disney is quite prolific in this case, because they have many, many different brands, many, many different characters, and with it, many, many different trademarks to license out and monetize. And once you do this, you engage in a trademark licensing arrangement. You generally, licensors get to participate in revenue sharing of these licensed products and services through the payment of royalties, which is usually calculated as a percentage of the revenue that is generated by these products and services. So, like assignment, there are some key steps to take note of before you decide to license out your trademark. So likewise, you look at jurisdiction-specific requirements for what constitutes a valid license. So like assignment, in Singapore, a license needs only to be in writing and to be signed and assented to by the licensor. And a bit unlike assignments, licenses can be varied quite a bit. So they can be varied by the bundle of rights. So what we mean here is that the specific use of the license, maybe in terms of specific usage in terms of goods and services, usage in terms of how the trademark can be marketed, can be represented to the public, and things like that. So that is how licenses can be limited. Next, licenses can be limited in terms of the operation in the different territories that the licensee can operate in. Thirdly, licenses can be limited by the term. So likewise for assignments, you can limit it 1-2 years, the perpetuity, for example. And finally, licenses can be either exclusive or non-exclusive. So what I mean here is that the bundle of rights that you grant under a license, it can be solely for one party only and not to be shared with any other party, or it can be shared amongst many, many other parties. So in the first instance, it will be an exclusive license. In the second instance, it will be a non-exclusive license. So before you embark on a trademark licensing agreement, here are some important clauses to consider, which I will be explaining one by one. First is to consider the scope of the license, which in the previous slide I mentioned talks about the bundle of rights you want to grant, the territories you want to grant it in, term of the license, as well as whether it's to be exclusive or not exclusive. The next thing is to consider payment terms, whether or not you want to have an upfront payment, a percentage-based payment of revenue as per royalties, or installment payments of a fixed sum of some sort, or any combination of these three different common modes of payment. Next, very important for license, and indeed one of the key reasons why trademark owners license out their trademarks, is to ensure that a certain level of quality control is met, which helps to protect the trademark owner's reputation by specifying certain minimum standards that have to be met by licensee. And these standards generally will be standards that consumers rely on when making their purchasing decisions. So in all, QC obligations and provisions help to prevent damage to the goodwill of the trademark, and by extension, the brand value of the trademark. Okay, so next, we look at usage obligations. Oh, sorry. Usage obligations basically deal with how the trademark is to be used in relation to the goods and services. So in this regard, it's generally advisable for the licensor to provide an electronic version of the trademark, any artworks, designs, logos to be used by a licensee, so that the licensee is not creating his own version of the trademark. And license agreements should generally state that copies of the mark can only be made by whatever artwork that is provided by the licensor, and that any modifications to be made by the licensee must be first approved by the licensor. So next, looking at infringement clauses. So infringement is a bit interesting because under our Singapore's Trademark Act, under Section 45 specifically, an exclusive trademark licensee has the statutory right to pursue an infringement action on behalf of the licensor. That's a very straightforward position. But you contrast this with a non-exclusive licensee, there's a lot more leeway to play around with. So generally, you can vary how infringement claims can be pursued by either the licensor or the licensee. So, for example, you can give the right to pursue infringement solely to the licensor, or to allow the licensee to pursue the infringement, but only with prior notification and consent from the licensor. And next, and very, very importantly, representation and warranties, trademark license agreement is important because it deals with the state of the trademark. So these representation and warranties clauses generally deal with things like representing that the owner of the trademark is represented, that the mark is not encumbered by any security or lien, that the mark is not subject to any infringement, revocation, invalidation proceedings, and the like. So it's important to clearly state that the mark is provided in the best condition possible. And finally, looking at governing law and dispute resolution provisions. For governing law, because as everyone will understand, trademarks are generally territorial in nature. They are based on the country in which they are registered in. So generally, it will be advisable for parties to have the trademark license agreement to be governed by the law in which the trademark is registered in. And then finally, about the dispute resolution provisions, depending on how the parties would wish to resolve the dispute, options to refer the dispute to arbitration, to mediation, or to a court of a specific jurisdiction is always open and is always up to agreement for the parties. So with that, I have come to the end of my presentation. So next up is the Q&A session. We will be looking to answer some of your burning questions that you might have had during the presentation. So with that, I'd like to invite Bern to help us moderate this.
Yeah, so now we have the Q&A session, and we have Kevin, our director, who's here to answer some of the questions as well. So maybe to start the ball rolling, one of our attendees has asked, because this whole presentation is about trademark ownership, so they have asked, one of them have asked, like, they have already applied for a trademark, but how do I know what I can do to expand my mark in my business? So maybe Bryan or Kevin, you want to give some of your comments? Yeah.
Sorry, can I hear the question again?
Yeah,
Second part of the question.
let's say you already have a trademark application, you already applied for a trademark in a
Yes.
specific country, but
Yes.
now they want to know how to commercialize it or expand expand the business based on this application. So do you have any comments in relation to that?
Okay. So basically, the answer would largely rely on the extent to which you have used your trademark. So in the case where, okay, let's take it with two scenarios. The first scenario is that your mark represents something that's a very new and nascent business, which uh, may not have accumulated sufficient reputation or goodwill in this case. Then it might be in your best interest to commercially use the mark first before considering how you might want to either assign or license the trademark. Because oftentimes licensing arrangements come about when there's sufficient reputation and goodwill that's amassed by the mark. Or in the alternative, you can always reach out to a third party to cooperate in terms of a licensing arrangement wherein you engage the services of the third party to help to distribute your product, to market your product under the brand, and then you get a cut of the royalties, whatever that is earned. So that is always open to you. So the second scenario would be if your brand is very established already, you can always consider a single licensing arrangement where you would probably be able to have a greater bargaining power as well as greater flexibility in terms of how you want to license your trademark. You can either choose to franchise it if you have certain know-how, goods and services that you feel is very valuable and can be scalable in terms of passing it to a third party and operating. You can always merchandise depending on what kind of trademark this is, or you can always rely on alternative third-party distribution channels to distribute goods and services based on your mark. So it really depends on the nature of your business. It really depends on how extensively you use your mark.
Another question in relation to the previous one is, from a franchise business perspective, how do I really know who owns the IP and what should I look out for when I'm operating my business? Maybe Bryan, you want to start?
Yeah, sure. So for a franchise, how do you know? Okay, franchise is not okay, depending on the jurisdiction. In Singapore, a franchise is not a strict legal term. So you can basically choose to run your franchise in the way that your franchise agreement dictates. So in this connection, whether or not you own the IP will depend on the terms of the franchise agreement. So if you want to exert control on your IP and your trademarks, then it's always open to you to say that you want to license it out instead of signing it for the term of the franchise. So that's the first part of the question. Second part, sorry, Ben, can you remind me what the question is?
So from a franchise, what should they be looking for when they're operating their franchise business? Maybe from a legal perspective, yeah.
Okay, so very importantly, and what commonly arises in a franchise agreement, which goes back to why I think licenses might be preferable, is quality control. Because when you franchise out your mark, naturally you have some expectations in terms of maintaining the quality that your mark has been associated with and the reputation that your mark has generated. So you, in your franchise agreement, your license agreement, you should clearly have quality control provisions to allow licensors to, for example, routinely inspect manufacturing facilities or routinely inspect the shops that your franchisees are running. And also maybe include a provision that says that there is a franchisor's handbook, which with guidelines to follow, things like that. And include provisions to enforce these quality control obligations should the franchisee fall foul of these obligations. So punitive measures like paying additional costs or forfeiting a portion of the revenue, things like that. So there are many ways to ensure that quality control is there and you maintain and preserve the reputation that you work so hard to generate for your mark.
Okay, thanks, Bryan. Kevin, do you have anything that you'd like to add in relation to Bryan's comments?
Yeah, hi. Yeah, this is Kevin here. Perhaps I'll just add the point about I think uh, the essence of a good franchise business operation. I think really stems from the system for protection of the valuable IP of the franchisor having taken place at an early stage. When companies, first set up and they are developing a business model that becomes, potentially franchisable down the road. At that early stage, when they are, developing a business, even possibly before they even think of franchising, it should be at that early stage that they really think about what's the value proposition in their business and how that relates to the various kinds of intangible assets that they own or they claim to possess as part of the operations of the business or the output of the business. So if it's all developed at an early stage in terms of getting applications filed for various kinds of IP that relates to their business. Obviously, we're talking about trademarks here. Every business would have brands to protect. So that's one of the first few things that comes quite easy to come up as targets for protection. And then you have, of course, the other types of IP, depending on if it's a high-tech industry, then we might be looking at patents. There could be things like trade secrets. They're not registrable, but that once you know that you have them, then you find strategies and ways of ensuring that those kinds of IP, unregistrable IP, are protected. Then you might have industrial designs because you are selling a product with an aesthetic appearance that is unique. So you get all this protected even before you market the products, because as you know, with certain kinds of IP, the moment they are disclosed to the public, you have a huge problem even trying to protect those kinds of intangible assets. Yeah. So I think the in a nutshell, getting things in place early, protection-wise, puts you in a good stead for having a good franchise structure ahead, where your franchise agreements already spell out what you actually are claiming as a franchisor to be the owner of in terms of IP relating to the franchise business. Yeah, that's why.
Thanks, Kevin. So another question that we have relates to the extent of commercialization of your trademark. So if let's say your mark is only applied for certain goods and services, so registered for certain goods and services, can they then commercialize or license these products? I mean, the mark for only these goods and services, or can they cover more like other kinds of goods or services as well?
Okay, yeah, if I can take that. Basically, a license is something that is derived from your current trademark rights. So you, under a license, you basically cannot give what you don't have. So to answer your question, if your mark is only applied for certain goods and services, then you can only license use of the trademark in relation to these goods and services that you have registered your trademark in. So if you want to go beyond, then the onus will be on you to maybe adopt a fresh registration for the same mark in relation to more goods and services, and then you try to commercialize and or license the mark from them.
Okay. So another question relating to licenses: is it necessary to register a trademark license with the Singapore IP registry, or is it okay? Like, can we not register a trademark license?
Okay. For a license of a trademark, okay, so in Singapore, the recorder of a license with our registry, which is IPOS, is not strictly required for the license to be valid. But that being said, the recorder of license is very useful for the key purpose of making sure that third parties who come across this registered license will know and have notice of this registered license. So practically speaking, this is important. Firstly, for exclusive licensees who have acquired a bundle of rights that are exclusive to them, they can then rely on this registered license to say that this whoever third party which acquires a conflicting exclusive right that infringes on their current rights under the license, they can then rely on this registered license to say that no, this is not allowed because I've already have an exclusive arrangement with the licensor. The second thing is for licensees in general. It's important to register a license because in case the licensor decides to sell the trademark to a third party, it will be important to rely on this recorded license to say, hey, look, I have recorded this license. There is very clear evidence that I have certain rights with regards to the usage of this trademark under this license with the previous owner. So all in all, it's practically speaking quite important to register a trademark license in Singapore.
Okay, thanks, Bryan. So Kevin, do you have anything that you'd like to add in addition to Bryan's comments on whether we should register our licenses with the IP authority in Singapore?
Well, not in particular. I think if you're talking about the Singapore context, I think one good thing to note is well, registration of a license similar to the procedure for registering or recording a change of ownership and assignment. The processes are quite similar, and the Singapore IP office isn't very fussy or particular about actually having to have sight of the the relevant documentary evidence that supports the transaction, be it an assignment or a license. So that there are generally two options for recording these kinds of transactions. One is if there is a so-called authorization that is received from the two parties. Essentially, in the case of a license, the licensor and the licensee, the grantor and the licensee. Then there can be a transaction that is the transaction can be so-called validated by let's say the service provider, the agent who is filing the recordal for the parties. There would not need to be a license document actually being submitted to the IP office of Singapore. But of course, if that authorization is not available, then there's of course the other option of lodging or submitting a copy of that document. So it's a fairly straightforward process, especially if the authorization from the parties transaction is available and is provided. Yeah, so that's why I have to add. It's a very easy process, not so tedious. It doesn't take too long for the IP office to complete the recordal process internally. Thanks.
I see. Thanks, Kevin. So moving on to the trademark application itself. So we have a question regarding how do we know what kind of classes suit our trademark when we are trying to apply for a trademark in Singapore or be anywhere else in the world? So what should we look out for if you have any comments?
I think this question is quite open-ended. It really depends on the types of goods and services that you seek to register. But ultimately, what I think is that because there are so many different classes, classes 1 to 45, I think it would be important to get an appointment with proper IP professionals to properly understand what your goods and services are before they can give proper recommendations as to the class that you should register your goods and services in. So without understanding what your goods and services are, I think it's a bit difficult to give you a definitive response here.
Okay, so thanks, Bryan. So Kevin, do you have anything that you'd like to add in relation to Bryan's comments?
This relates to the question on how do I know what classes suit my trademark, correct?
Yeah, like what classes suits the trademark? Like what classes should be covered by the trademark? How do I know when I'm applying for a trademark?
Yeah, it's I mean that there are ways or means of coming up with your own idea or impression of what the classes might be, because there is information available online on the what we call the classification system is called the needs classification system, and one can go on the internet and find out a bit more about which class what each class corresponds to in terms of generally what kinds of products or services come under those classes. So that can give you a general idea, but there can be certain nuances or peculiarities which may not come up so obviously or clearly to one who is not too accustomed to the system itself. And especially given the fact that we may have a business owner who might be interested in applying for registration of a trademark in multiple countries. There may be certain peculiarities. There are country-specific peculiarities which the business owner may not be aware of. And so that's where I think the so-called experts, the trademark practitioners out there, would be well placed to provide certain kinds of input on what would be the best strategy in terms of scoping of an application, in terms of the classes, as well as specifically what descriptions of goods or and/or services should be claimed. I can give you one example, just one example, because I think we're running a bit short time. In the case of China, some business owners may not be familiar, especially if they are into the retail business. They might want to claim in their protection for a China trademark application, the claim for retailing, or what's it called? Retail of goods or something to that effect. Or retail services. I think that's the more generic term that's used. But the thing about China, for some reason, they do not accept retail services in that broad description as an acceptable description for claiming in a trademark application. So this is just one example of some issues that may crop up for certain countries but not others. But if you're not accustomed to how these things work from one country to another, you might end up in a possible complicated situation of receiving objections or of various other issues which might hinder your process of getting registration.
Okay, thanks, Kevin, for your input. So as we are running slightly behind schedule, I think I'll wrap up our presentation for now. So thanks everyone once again for coming to our webinar, and we really appreciate the time that you've taken off to join us in this session. And if you have further...
Sorry, would you mind if I just add on? Just one.
Sure, she wants to add on.
Yeah, just one more, because I saw one interesting question. Let me see what it was. I'll just talk about it very briefly. There's this question: is it a good idea to use a random name generator to come up with a random name to avoid the problem of inherent registrability or inherent registrability problems of a descriptive or generic trademark? So to avoid ending up having problems because you've come up with a descriptive mark. I would just add some input based on some things I've known, I've been so-called exposed to from experience. So I think that the answer to this question is yes. This is a way of coming out with a inventive enough word. I mean, if it's a generator that comes up with a word that doesn't exist in the dictionary, then of course you're coming up with a name that starts off at ground zero or on day one as a unique identifier or origin. So there are various kinds of brands that have this kind of origin or starting point. But of course, one must also bear in mind that what may have started out as invented, purely invented and through random name generator or otherwise, can eventually, unfortunately, through misuse. I think this was something that Bryan did point out during his presentation, through misuse over time or misuse that was allowed to continue amongst within the business, the brand owner's business itself, and or the public, that invented word that was previously randomly generated may end up becoming a generic term in the marketplace. There was a brand that ran into this problem. I think they have done enough to try and ward off the issue, but they went into a lot of resources to stop the generic side of their brand. That's of course a term that has been coined. I think some people may have heard of the generic side of a brand or that sort of coinage terminology. And this brand is, as an example, is Velcro. Now, Velcro started off as a purely invented word. It was a combination, a bit of French influence in the coming out of the brand name. But it's a word that didn't exist in any English, any dictionary, and I believe it doesn't exist in English in any dictionary at this point either. But there was a point when, as you all know, this is a product where you use it for fastening. A lot of products out there, could be bags or whatever, might use Velcro as a means of fastening for the product itself. And over time, unfortunately, some people might have been using it as a verb, so that can spell the end of a unique brand. But the brand owners, Velcro, they invested in a lot of advertising and publicity to try and get people to do the right thing for their brand, and to make sure that they were recognizing it as a brand and not using it as a descriptive term. And there was even something you can see on YouTube. If you search well enough, you might even locate a video that they have on YouTube right now, which is a very funny video, very humorous, very well done. And I think it really helped them put out the right message out there to the public, not to put their brand into generic side. Yeah. Okay. Yeah. So that's all to that. Thanks.
Oh, thanks for sharing, Kevin. And to whoever that asked, to the attendee that asked this question, thanks for asking such an interesting question. So yeah, yes, I'm running slightly behind schedule. I'm afraid we have to wrap up the webinar, and I hope that everyone who has attended has learned something useful from our webinar session today. And if you have any further questions, do feel free to direct them to our general mail, which will be shown in the chat box. So it's mail@ellachong.asia, and we will be more than happy to assist with your inquiries. So with that, we've come to the end of the webinar, and please also help us to fill in the survey form, which will pop up on your screen after you've closed this Zoom browser. So thanks everyone for coming, and see you all soon. Have a nice day. Bye.
Thanks everyone. Bye-bye.
Thank you.